Bledsoe, is that how you pronounce it?
Bledsoe.
Bledsoe. Okay, he is going to be up here and talk to about present a case for nullification and actually how it pertains to the 10th Amendment and all that sort of stuff. So I'm going to turn it over to him. Come on up and give him a normal welcome.
How's everybody doing? Can y'all hear me? All right. Well, the federal government does not do anything wrong in the end. Completely the opposite. Here we go. All right, I'm here to talk about nullification, the rightful remedy whenever the government goes beyond its powers. So basically, what is nullification? It's basically what it is. Well, first of all, I got most of my information, well, it all comes from the founders and stuff, but it's made palpable by Thomas Woods. He wrote a book called Nullification. I've seen multiple speeches by him. Read the whole thing. It's got documents in there that pertain to the Kentucky resolutions, a bunch of other supplement stuff to help you understand. It's a really great resource. So some of the stuff from him, this is basically what he boils it down to. Basically, it begins with the axiomatic point that a federal law that violates the Constitution is no law at all, and it is void and of no effect, and it is up to the states, the parties to the federal compact, to declare it so, and thus refuse to enforce it. The central point behind nullification is that the federal government cannot be permitted to hold a monopoly on the constitutional interpretation. They're not the final say. And this all derives from the compact theory, as opposed to the nationalist theory. The compact theory basically is bottom up. First of all, you must note that the states preceded the Union. The states were all sovereign entities, and then they came together and they agreed to go based off of this contract. Any other interpretation is kind of weird, because how can you have a union of two things older than the two things? It's just like saying that people are 40 years old, but they've been married for 50. It doesn't make any sense, no logical sense. So the states preceded the union. The second point is that we say states' rights, but that's just kind of like shorthand. States don't really have rights. It's the people. And everything is based off of the individual. That's what makes the system so important to human beings. Like that's what makes our system so special. The fact that we put the individual at the top of the ladder. All right. So from that perspective, the individual, you have rights. You're born with them. You have them already. And then you have a right to apportion some of those powers or some of those rights to another entity, say the state, and then from that point, from the state to the federal government. And in doing so, you're not giving up your sovereignty, you're exercising it. So it's not like you're giving up your rights by saying, here, do this. You're exercising it. So you fully retain all that. You're not giving it up. So therefore, it is the people who are the proper disputants as they review whether their agent, the federal government, was intended to hold such a power. An employee does not tell an employer what to do. So states came together, we created the federal government. They can't, they can't go past what we already told, what we expressly delegated to. So, well, how do we know what to nullify? How does that work? Well, Well, we just look to the Constitution. Just look at it. You know, even though the word nullification is not in it, as I will demonstrate, the very nature of the document makes this legitimate. Like the fact that it's in there. Especially since the people who signed it, they were assured over and over again in all the ratifying conventions, everywhere they went before they signed it, they were assured that the powers are the federal government only has powers expressly delegated. They use the word expressly delegated. They were assured this over and over. So then we just look at what is it? I mean, what is the Constitution? It's a piece of paper. It's got words on it. That's what it is physically. It's just a piece of paper. But this is significant within itself. Okay, this is if you look at the colonial era under the British Constitution, it wasn't written down. It was just based off of traditions and precedent. You know, there wasn't anything to point to. And so this allowed things to change with the times. You know, you had rights one day, and then you didn't have rights another. You know, when it first started, you know, the colonies were respected. You know, they were left kind of to their own, and then, you know, over time, you know, after the French and Indian Wars, then they really got, you know, into taxing power, you know, to the citizens and all that kind of stuff, and all of a sudden it's like, wait a minute, you know, our grievances aren't being, you know, attended to here. So that the point that is written down is something that we can specifically point to. It's like if they do something wrong, we can be like, hey, look, see, right there. So the point that it was written down is important. But then you get all these different interpretations, like, but everybody's, you know, living document, this means that, and that means that. So how do you know? Well, Madison told us, you know, you can look at the ratifying conventions. What were they told when they signed the document? When you sign the contract, when people tell you what this means, like, that's what you mean when you sign it. It doesn't change after the fact. Like, that would, you know, negate the whole purpose of a contract. From these discussions, and they argued and argued, these become the intentions behind the document. This is often known as original intent. This is where original intent comes from. Now, all these arguments, they're all said the same thing in different states. We'll mostly look at Virginia. Virginia was the most important state to sign the document. It was the biggest. If you look at the maps, you know, involves Kentucky and West Virginia at the time, which they had to cede to the Union once they signed the contract. But regardless, you know, you get all, you know, Jefferson and Washington and Madison, these are all Virginia, so it's like a lot of prominent people. They had a lot of power, so we'll look at those states, but they're basically all set in all the states. And another thing to notate is that the arguments that they had whenever they were trying to sign the document, it wasn't whether they should have a national government or a federal government or this government. It's like the arguments that they were having were, does this document restrain the government enough? Like, that was the argument they were having. Does it do that purpose? It wasn't, you know, should we have this or that government? Does it do it enough? Like, that's what the arguments were about. And if you look at the Virginia ratifying convention, they set up a 5-man commission to basically come up with the document, like the words that they were willing to sign. So it's like they review the document, look at the words, and if anybody had any grievances, and they would go to them, and they would flesh it out, basically. And people like Patrick Henry, they didn't think that the Constitution did enough to restrain it. They didn't think that was enough. There's always clauses in it that people could just abuse. You know, the Commerce Clause, General Welfare Clause, Necessary and Proper Clause. You know, people can interpret this stuff. They're like, hey, you know, they can take this and just go to the moon with it. You know, it turned out to be correct, but, you know, that was his argument. And then, so, we go to the ratifying conventions. Well, one of the guys that was on that was Edmund Randolph. He's a Virginia Attorney General. He eventually became the governor of Virginia. And he looked at Patrick Henry with all these arguments, and he said, he told him, straight blank, in the ratification, we put words to this purpose, that all authority not given is retained by the people, and that no right can be canceled, abridged, or restrained. I conceive that, as this style, the document, of ratification would manifest the principles on which Virginia adopted it, that we should be at liberty to consider a violation of the Constitution every exercise of power not expressly delegated therein. I see no objection to this. He said expressly delegated. They have no more powers than that. That's what he told them. And then another guy, a prominent guy, George Nicholas, he's a future Attorney General of Kentucky. He also told them, if 13 individuals are about to make a contract and one agrees to it, but at the same time declares that he understands its meaning, signification, and intent to be what the words of the contract plainly and obviously denote, that is not to be construed as to impose any supplementary condition upon him, and that he is to be exonerated from it. Exonerated from it. They can exercise no power that is not expressly granted. So that's basically nullification right there in the ratifying conventions, even though the word hasn't been invented yet. And just to go over the disputed clauses, just to clarify, I'll go over the Constitution. Clarify its intent. So if you look at the General Welfare Clause, which is the first little section, Article 1, Section 8, which that part of the Constitution is the delegated powers. It's right there. It's Article 1, Section 8. It says the Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. Now Madison made the point, they're like, they can just do this for the general welfare. Any kind of, tyrannical dictator says, I'm going to do this for the general welfare, whatever they say, they'll volunteer. We're doing this for the good of the people, But Madison was like, well, he said, in Federalist 41, for what purpose could the enumeration of particulars be inserted if these and all others meant to be included in preceding general power? Why would we just give it whatever, as many powers as it wants, and then just list specific powers? Why would you need to put needful buildings in there, Why would you do that if you just gave it a blank check to do whatever it wants? So that was his argument. And I really like this quote. He said in 1792. You see, he was trying to give off the ridiculousness of that claim that they have as much power as they want. I really like this one. It says, if Congress can employ money indefinitely to the general welfare and are the sole and supreme judges of the general welfare, they may take care of religion into their own hands. They may appoint teachers in every state, county, and parish and pay them out of the public treasury. They may take into their own hands the education of children, establishing in like manner schools throughout the Union. They may assume the provision for the poor. They may undertake the regulation of all roads other than post roads. In short, everything from the highest object of state legislation down to the most minute object of police would be thrown under the power of Congress. He thought that was ridiculous. There's no way we would do that, but look what we got today. So basically, you can tax general welfare clause. If you read it, it says basically you can tax for these specific things under Article 1, Section 8, only to achieve the ends of general welfare. And that the taxes cannot favor one sex population at the expense of the other. Tax for these things only, and only if those things pertain to everybody equally. So that's what that means. That was the intent. That's what they were told. So the Commerce Clause says to regulate commerce with foreign nations. It's also under Article 1, Section 8. To regulate commerce with foreign nations and amongst the several states and with Indian tribes. Now, the part about among the several states was the part of most contention. The other ones were kind of understood, foreign nations, put tariffs and all that kind of stuff, and Indian tribes. But commerce among the several states. It was widely known that the word commerce, meant merely exchange, as opposed to anything and everything that involved gainful activity. That's the way they read it today. Anything that you do that you gain something, that's commerce. But it's really just the exchange. So the exchange. And to regulate meant to make regular. You're making stuff regular. That is, to function in a regular and orderly manner, as opposed to the words world's modern meaning that suggests micromanagement and control. So it doesn't mean that. It just means make stuff regular. So Tom Woods explains this. He says it pretty good. It says, thus the purpose of the Commerce Clause was to establish a free trade zone throughout the United States, thereby making commerce regular, and prevent states from disrupting the free movement of commerce. So basically, the states couldn't put tariffs on each other, as they did under the Articles of Confederation. That was the whole purpose of that. They wanted to establish where people could just trade freely. And then Madison pretty much makes this point. Among the several states grew out of the abuses of the power by the importing states in taxing the non-importing, and was intended as a negative and preventive provision against injustice among the states themselves, rather than as a power to be used for the positive purpose of general government. So that's basically what he said. So this was the intent behind the common law. There have been abuses, guy growing wheat in his own yard, and he doesn't sell it to anybody, he just uses it on his own, he has extra, and then so, the federal government felt necessary that they can regulate him because he withheld that wheat from the market. That affect the market. See how that works? That's not the case. I forgot what the actual thing was, but I just reminded myself of that. We'll go to necessary and proper. This is at the very end of the article in section 8. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested in the Constitution, in the government of the United States, or in the department of the officer thereof. This is known as the elastic law. It did not grant any additional powers, though, as they would come to do, but allowed the government to perform simple tasks that were clearly incidental in carrying out its enumerated power. As you can see, it says, for carrying into execution the foregoing powers. So if you, like needful buildings, we authorize you to have needful buildings, like, I was about to say that, yeah, I don't think that's needful buildings. They would need to buy lumber, so it's not in the Constitution they can buy lumber, but, in making the needful building, they can buy lumber. That's the necessary and proper clause. And instead of saying necessary and proper under each power delegated, they just put it in one clause rather than just repeat it over and over again. And this was said multiple times, over and over again. George Nicholas, there was no augmentation of powers. Madison said the clause gives no supplementary powers. McLean in North Carolina, the clause gives no new powers. Pennsylvania Chief Justice, it gives Congress no further powers than those enumerated, etc., etc., etc. So this is what people were told. And then lastly, the supremacy clause. What about the supremacy clause? Isn't it the law of the land? Well, let's read it. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made and which shall be made under the authority of the United States shall be the supreme law. So the only thing that is law of the land is the powers delegated to in Article 1, Section 8, in pursuance thereof. That's what that means. So, as you can see, that's how the document was laid out. That's how it was sold to the people. And it was assured over and over again. But people still had reservations. It barely passed. Because there was I don't think it's enough. What's going to stop them from this, even though they were sure over and over. So then they even passed the Constitution with the promise of a Bill of Rights. And there was a discussion about the Bill of Rights. So one of the arguments was, probably a decent argument, is if you list some rights, that would assume that there's rights that you don't have. How are you going to list all your rights? Your rights are as enumerable as these are. You have the right to go to Taco Bell. You have the right to, mow your lawn at, a certain time. You have a right to do certain things. So you're going to leave all this stuff out. That's what the Ninth Amendment was. What it says. It says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others obtained by the people. So they listed all the important ones, free speech, freedom of religion, no searches and seizures without probable cause or a search warrant from a judge. And then they ended with the Ninth Amendment, or not ended with the Ninth Amendment, but they went by this and said there's other rights just because we didn't listen. Specific. And then here we come to the cornerstone of the Constitution. This is what Jefferson called it. Okay, this is the 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Okay? So this is pretty much the whole Constitution, what I just described. Only they wrote it down. They didn't have to write it down. It wasn't necessary, but they did. Just as an extra guarantee, because people were worried that the government would overstep the bounds. Yeah. So the whole document is based off of this, and then they wrote it down specifically and passed it, and it's still in there. Alright, now, so that's the Constitution as a whole. We understand it to be that. Any other way to understand it, it just doesn't make any sense. You know, it just doesn't apply. Alright. I can go through the history of the use of nullification. In 1798, John Adams was dealing with the so-called quasi-war with France, which his policies sparked criticisms of him and his administration. A guy named Benjamin Franklin Bach, Benjamin Franklin's grandson. He was the editor of the Philadelphia Aurora and an adamant Jefferson follower. You can imagine what he wrote about him. In fact, he called the president an old, querulous, bald, blind, crippled, toothless Adams. Which, yeah, it's pretty rough, huh? Which led to Federalists calling for his punishment. Other reporters, and there's lots of talk like this. So, and this and other incidents led to the Sedition Act, which passed based off the General Welfare Clause and the Necessary and Proper Clause. Ironically enough, just 10 years after the ratification, for less than a decade. And then we'll just read it. There's the Alien Acts too. They had beef with that, basically the same thing, but just for simplicity, we'll just talk about the Sedition Act. And if you read it, it says, if any person shall write, print, utter, or publish, or shall cause or procure to be written, printed, uttered, or published, or shall knowingly and willingly assist or aid in writing, printing, uttering, or publishing any false, scandalous, and malicious writing or writings against the government of the United States, or either House of the Congress of the United States, or the President of the United States, with the intent to defame the said government, you'll be punished. And that's pretty specific. Now, as a result, this was passed in July 1798. And as Adams was returning back to his house, in each town that he came across, there was cannons being shot off in his honor. It's like, hey, Adams is here. A guy named Luther Baldwin in New Jersey, while at a pub, heard the cannons fire, and just as a joke, he's like, there goes the president, and they're firing at his fat arse. And I hope that it goes through his arse too. And he was sent to prison and was fined in court, so he was arrested. Another instance in November of 1798, a guy named David Brown put up a liberty pole in Denham, Massachusetts, with the words, "No Stamp Act, no Sedition Act, no alien bills, no land tax, downfall to the tyrants of America, peace and retirement to the president, long live Vice President Jefferson." And he was fined and sentenced to 18 months in prison for putting up a pole with words on it. Representative Matthew Lyon, he's the guy, I don't know if y'all remember history class, or maybe he's the guy that was hit with a hickory stick on the floor. Not for this, but pretty close to this. He published a letter which wrote of Adams's continuous thirst for power. This thirst for ridiculous pomp, foolish adulation, and self-avarice. And he was sentenced to 4 months in prison and fined $2,000. A representative of the Congress. And funny about that is that he actually ran for re-election while in jail and won. And yeah. That's the way it's looked at. Now, if you read this carefully, who is left out of the text? We got the government of the United States, House and Congress, and the President. Someone missing right there in the middle. Vice President, who was Thomas Jefferson. He was left from coverage. You can say whatever you want about Jefferson, but not the President of the Congress or any of those. Now notice the President was a Federalist, and the Congress, they were all Federalists too. So, and don't think Jefferson didn't notice. He was actually, there's a lot of there's less correspondence from him during this time because he thought that his mail was being opened. So he was concerned about that. So he asked himself, what's to be done? All three branches were controlled by Federalists. What happens when a power not delegated is usurped and approved by all three branches? You can't go to the Supreme Court. They're part of the problem. Tom Woods makes an example. It's like if you and me had an argument, and I was like, I know the best way to settle this dispute. We'll ask my mother. It's not fair. She might side with you, but most likely not. They're part of the problem. So there has to be another way. They can't be the ultimate deciders, arbiters of the compact between the principals and their agent. This is the basis for which Jefferson and Madison drafted the Kentucky and Virginia resolutions. And these documents are awesome. They're mainly forgotten in U.S. history. There was no bicentennial of their awesomeness. And we'll just go ahead and Kentucky resolutions were written by Thomas Jefferson. Of course, he didn't put his name on it, but he wrote them and sent them to Kentucky so that they can pass it. And basically said, resolved that the several states proposing, the United States of America are not united on the principle of unlimited submission to their general government, but that by a compact, it says compact, under the style entitled the Constitution of the United States and of the amendments thereto, they constituted a general government for special purposes, delegated to that government certain definite powers, reserving each state to itself the residuary mass of right to their own self-government. And that whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. That is, to this compact, each state acceded as a state, and in an integral part, its co-states forming as to itself the other party. So the co-states came together and they created the federal government. That the government created by this compact was not made the exclusive or final judge of the extent of its powers delegated to itself, since that would have made its discretion and not the Constitution the measure of its power. So that's right there. But that, as in all cases of compact, among powers having no common judge, each party has an equal right to judge for itself, as well as infractions as the vote and measure of redress. It just says it right there. The states have the final authority, the states and the people. The final authority to say when the government has infringed on its powers that they expressly delegate to it. And then Virginia, at their resolutions written by Madison, he used the word interposition. States as like to interpose between the federal government and the people, like that's a protection. And you got this to say. That this assembly doth explicitly and peremptorily declare that it views the powers of the federal government as resulting from the compact again, to which the states are parties, as limited by the plain sense and intention of the instrument constituting the compact, as no further valid, that they are authorized by the grants enumerated in that compact, and in that case, of a deliberate, palpable, and dangerous exercise of those other powers not granted by the said compact, the states who are the parties thereto have the right and are duty bound to interpose for arresting the progress of the evil, and for maintaining within the respective limits the authorities, rights, and liberties appertaining. You're duty bound. You don't just one day say, all right, I'm gonna fight the federal government. Okay, this day I'm not. You're duty bound once it does it, because once you let the flood out of the gates. He does it once, it's gonna do it all over the place. Now the states, there were some states that were indifferent. Other southern states didn't really say much, but the northern states that were opposed to it, of course, they were all mostly federalists. They denounced it. It's like, no, it's the Alien Sedition Acts, they're constitutional. Based off of what grounds, I don't know. But they're like, this doesn't affect us, so it's okay. That's basically what they said. So in 1799, Kentucky came out with their second set of resolutions, also written by Jefferson. And this time, in the previous one, he left out the word nullification. Well, in its original draft, he had it, but the Kentucky, they took it out because they thought that was too extreme language and something like that. So this time, they doubled down. They're like, all right, you have a problem with it. How about this? And the principle in construction contended for the sundry of the state legislatures that the general government is the exclusive judge of the extent of the powers delegated to it, stop nothing short of despotism, since the discretion of those who administer the government, and not the Constitution, would be the measure of their powers. That the several states who formed that instrument, being sovereign and independent, have the unquestionable right to judge of its infraction, and that a nullification by those sovereignties of all unauthorized acts done under color of that instrument is the rightful remedy. This is where the word nullification becomes part of the lexicon. You get the idea from the ratification, but this is where he puts forth the term. Jefferson came up with that. We didn't come up with that. That's part of it. And also in Virginia, Madison came up with a report of 1800. Sorry, you got to read all this stuff. These are the important documents. You don't read a whole bunch. Came out with a report of 1800. Looked at all these different arguments based off of the Federalists saying, that's not a right, and they doubled down on it. Said the resolution supposes that dangerous powers not delegated may not be usurped and executed by other departments, but that the judicial department also may exercise or sanction dangerous powers beyond the grants of the Constitution. Basically the Supreme Court, they can betray us. They can't be the last one. And the ultimate right of the parties to the Constitution to judge whether the compact has been dangerously violated must extend to violation by one delegated authority as well as another, by the judiciary as well as the executive or the legislature. However true, therefore, it may be that the judicial department is, in all questions submitted to it by the forms of the Constitution, to decide the last resort. This resort must necessarily be deemed in the last relation to the authorities of other departments. So you can, the president can veto congressional laws, and then the Supreme Court can, what's the term? Separation of power, rule unconstitutional. They can check each other, but what if all three of them agree, and who's there to check it? So that he doubled down on Virginia Report of 1800. Now, of course, the thing about the Alien and Sedition Acts is that it had a sunset provision to end whenever Adams left office, so it had a 2-year provision. So lucky for him. Now, you remember all the northern states, they were opposed to these resolutions. They're like, no, that's not right. You don't have the right to nullify, free all land and all that. Well, less than 10 years later, Jefferson administration, in 1807, during the Napoleonic Wars, there were searches and seizures of cargo and impressments of American citizens by the British, and they're getting. And Jefferson, instead of going to war, he decided on an embargo. And the embargo that was instituted prevented any merchant ships from traveling to any foreign port anywhere. Also permitted searches and seizures of the ships or goods on the mere suspicion of the intent that they were going to export it somewhere else. This actually led to death threats to Jefferson. He got a lot of letters, some nice, some bad. And Massachusetts' response in 1809 condemned the embargo as, in many respects, unjust, oppressive, and unconstitutional, and not legally binding on the citizens of the state. So, using the language of the Principles of '98. Connecticut Governor Jonathan Trumbull said, whenever our national legislature is led to overleap the prescribed bounds of their constitutional powers, it becomes the state's duty to interpose. They're using the language of Madison. And then the Connecticut legislature drafted a resolution with similar language. And Rhode Island also followed suit. Then we go to the Madison administration. During the War of 1812, instituted his own embargo and got called out on his own words. They're like, don't you remember 10 years ago what you said? Massachusetts, it says a power to regulate commerce, a power to regulate commerce is abused when employed to destroy it. The sovereignty reserved to the states was reserved to protect the citizens from acts of violence by the United States, as well as for the purpose of domestic regulation. Okay, so they're using this language that was already preceded. They said that wasn't legitimate. All of a sudden it's turned around on them, and all of a sudden it's okay. So anyway, so the war ended with the Treaty of Ghent. As a result, Congress entertained the idea of military conscription, which the bill was never passed. but that the possibility of it being passed caused a Connecticut legislature to pass a resolution with similar language. So, as is with Obamacare, everybody just put out the resolutions like, we're not going to force this even though it hadn't been in effect yet. In Ohio, 1820 against the Second Bank of the United States, Ohio said the General Assembly does recognize and approve the doctrines asserted by the legislatures of Virginia and Kentucky, and to consider that their principles have been recognized and adopted by a majority of the American people. Okay? Virginia, 1826, against internal improvements done by the federal government without a constitutional amendment authorized. And then South Carolina, probably the most famous other than the Virginia-Kentucky resolution, was against the tariff of abominations. In 1828, they raised the taxes. It definitely benefited the North merchant class rather than affected the Southern agriculture. So they're like, based off of these two things, that the tariffs were for the purpose of raising revenue, not to protect domestic industry at expense of consumers. And second, to the end of general welfare, and that not particular welfare of one section can benefit one and the expense of the other. So, and President Jackson did not like this, saying he condemned the actions and even got a bill passed called the Force Bill, and it was supposed to use the military to collect the tariffs. Be like, well, I'm going to use the military, and you don't pay up. And then eventually a compromise was reached before the deadline, and gradually the tariffs lowered over a 10-year period. Some people would say that, that means it doesn't work, but if South Carolina didn't do anything, how much more taxes would they pay? So it's the act of doing it, asserting their rights, that got stuff done. And this next one's important because nullification is usually regarded as a Southern doctrine, and it was used for slavery, to keep slaves enslaved, basically. And so this is kind of going to be called a neo-Confederate, all this kind of dirty language, saying that you're going to instill slavery again. But nullification, in fact, was never ever used to protect slavery. It was actually used the opposite to against slavery. We looked at the Fugitive Slave Act of 1850. There is a fugitive slave clause in the Constitution, but that does not imply by any means necessary. One, they lacked a proper jury trial. Bystanders could be forced to assist capture. Fugitive slave commissioners received $10 to return accused and $5 to set them free. So not really much incentive to set them free. And a lot of this was just based off of their just coming in there and be like, that guy right there, that looks like my slave, and then they would just take it. It was kidnapping, basically. And one story, Joshua Glover, should look him up, it's a pretty interesting story. 1854 in Wisconsin, he's an escaped slave, and some guy decided he wanted to collect, so he told the marshals, and they busted in, and they jailed him at the house. And a guy named Sherman Booth, a newspaper editor and abolitionist, riled up all the people. He rode around and was like, look at this, they just busted in here and just took one of our citizens, out of nowhere, just jailed him, they're going to send him back. And he gathered about 5,000 people in front of that jail. And they called for his release. And they decided to do it themselves. So they just busted in the jail, cracked open the door, got him out, and a couple of safe houses later, he got up to Canada. Well, Booth didn't escape the wrath, though. He was arrested. Sherman Booth was arrested and put before a federal court, and he was released based off of habeas corpus twice. And the Wisconsin State Supreme Court was uncooperative in submitting proper records to the Supreme Court, so there's a lot of trying to keep this from going any further, just causing kinks in the system, basically, until about 1857. And then after they finally gave the little records, the Supreme Court ordered Booth to be turned over, but the state Supreme Court refused. And then the Wisconsin legislature in 1859, said that we support our state Supreme Court for doing that. It says, resolved that the government formed by the Constitution of the United States was not the exclusive or final judge of the extent of the powers delegated to itself that a positive defiance of those sovereignties of all unauthorized acts done or attempted to be done under color of that instrument is the rightful remedy. And here you see the language again, over and over again, throughout history. Then you come to the Civil War, and people confuse nullification with secession, based sort of on the same principle, but the difference is secession is actually relieving the Union. Nullification is applied to preserve the Union. That's the point. You're asserting your rights and making them follow that document, because that's what the Union wants. So nullification is preserving them. It's not about secession. In fact, the South, they listed one of those as the grievances, because the North was using nullification to go against the future slave acts. That was one of their grievances. So, plus, what would they have to nullify? The Constitution was perfectly fine with having slaves. They wouldn't have any kind of legislation to nullify in regards to slavery.
Got a question?
Yes.
Looks to me like a lot of things, a lot of what you've been saying, you're ignoring the 10th Amendment.
Oh, it's precisely the 10th Amendment that solidifies nullification. It's not all powers delegated. It says all powers not delegated to it are reserved to the states.
Reserved to the states. Right?
Yeah, exactly. So, and
so in our society to go against the South, they violated the 10th Amendment right there.
who did?
When Abraham Lincoln, Northern states decided to impose their police and settlers on the southern states, they violated the 10th Amendment. Exactly.
Oh yeah, basically. Hey, it was based. Well, it's kind of like ambiguous. In some sort, Lincoln always said that they never seceded. You can't secede. I'm going to force you not to. Like, he didn't recognize it in some aspects of it, but then he did recognize it in other aspects. It's like after the war, they had to be readmitted, but like before, they couldn't secede. So it's kind of like ambiguous like that. So yeah. That act basically used force. He used that precedent with Andrew Jackson, that force bill where he wanted to get South Carolina to pay. That was basically that's what basically it was all about, collecting taxes. It wasn't about slavery.
I appreciate your address.
Well, I can go further into it.
That's right.
And then some people would say the Civil War settle this question, and Tom Woods, he makes a pretty good couple of points. It's like, if I were to say that the sky is blue, and you say it's brown and green, and you throw a brick at my head, does that make the sky brown and green? Would you not consider it unspeakably grotesque and morally outrageous to declare the U.S. Army settled the issue of the Plains Indians? So violence doesn't settle the issue, basically. So it's still there. Now we can look at recent nullification. Sorry. Been looking at that the whole time. Recent nullification. Real ID Act in 2005, basically National ID card, which has little RFID chips so they can locate you wherever you are. Doesn't. Yeah, unless you're illegal, they don't want to know where you are. You don't pay taxes. They just want the money. You're fine. The Real ID Act, it passed. It's still on the books today. But dozens of states nullified it, and we're not going to enforce it. So the federal government basically just gave up. It's still on the books, but they just gave up. That's kind of how it works. Firearms Freedom Acts in multiple states, basically. All, a gun was made in your state and only sold in your state, doesn't go out of the state, then you can't regulate our guns. That's passed in multiple states. Jury nullification, which the founders believed in. New Hampshire actually this year passed a law, first state ever passed a jury nullification law, and reads in relative part, in all criminal proceedings, the court shall permit the defense to inform the jury of its right to judge the facts and the application of the law in relation to the facts in controversy. So basically, if you had a man-made pond on your land and rainwater were to drip in it, and then the government came in and said, hey, you know, some kind of environmental protection law or something to do with tributaries, like you're doing something to that effect, and they arrest you, and go to court. You know, the jury could then say, no, that law is stupid. You know, even though he technically violated the law, we're going to nullify that law. A jury can do that. Yeah, that's important to know. So, if we all think that if taxing our wages, income taxes, you know, if we think that's unconstitutional, and we don't pay them, we go to court, we can have a jury, and if they think the same thing, they can nullify that, and we get on scot free. Putting that out there, in case y'all are ever on a jury. Medical marijuana, of course, California and other subsequent states. This is also nullification. It's a federal law against marijuana, but California and other states, they said, you know what? There's medical purpose for this. You know, we're just going to pass a law saying it's legal, so they do it anyway. And during that court case, I think around 2002, little Angel Rach, she had like scoliosis and all these problems, cancer. She had a tumor in her head. She couldn't eat or anything. A physician went up on the stand and said that the only way that she could eat and survive is with cannabis. Like that's just what it is. And so that's what the California law is all about. Whether it's used that way or not, you know, whatever. And then when it went to the Supreme Court, it was the liberals in the Supreme Court said that that was unconstitutional, that the state couldn't pass that law on the grounds of the Commerce Clause, based off the fact that the cannabis could spill over into other states. However, so it's not that whether it's a liberal issue or a conservative issue or whatever talking point it is, the federal government does not